impartiality and repeat appointments. I think it is indeed the case that at least the appointing authorities in matter of challenges, and I speak here with the experience of the ICC court, has taken the approach repeat appointments either from law firms or from the parties is not acceptable. And I think that is covered by the IBA guidelines, and I think that has been recently been applied quite strictly. So I would say, I would answer in the positive to the question. With respect to the Code of Ethics, one would have to ask what is exactly what we need to regulate. With respect to arbitrators, I think most of the rules of arbitration already cover obligations and sanctions to arbitrators that are to conduct themselves in an ethical manner. So I don't think that there is a real need for a code of ethics of arbitrators because the rules already cover that. Now the question is, what about counsel in arbitration? And here it's a more tricky question. Do we want to regulate the behavior of counsel? Well, lawyers, each lawyer in their own jurisdiction have rules of ethics. Can we create a universal code of ethics for arbitration? The IBA is working on a task force, and I can say that the question is, what do we want to achieve with that? What are we trying to protect? And many people are of the views that it is not necessary as long as at the beginning of the proceedings the rules of the game are clear for everyone. I think it's more a question of transparency of the procedure rather than trying to regulate at a higher level, something which can be quite difficult, but let's wait and see what the results of this task force are. With respect to case management, I would entirely agree. At the beginning of the case, in the case management conference, the arbitrators need to tell the parties when they're going to deliver the award, or at least to give them an estimated amount of time. The new ICC rules now provide for an obligation for the arbitrators to inform the parties when they are going to deliver the award immediately after the hearing takes place. Because we've seen that the big delay in issuing the awards comes after the hearing or after the post-hearing briefs. That's when the parties then don't know anything more about the arbitrators, and then this process can take long. So there is an obligation of informing the parties of the delivery of the award, and that is the trend that the ICC has followed. More presence in the region, I reiterate what I said, there is an obligation for the institutions, not only the local institutions, but also the international institutions, to ensure there is more diversity. And one area in which institutions can do that is in the appointment of arbitrators. I can tell you that in 2011, the ICC appointed 65 arbitrators from the region, and that is it's something that the ICC takes very seriously, and I think that's a way in which institutions can help increase the presence and the knowledge and education in the region in terms of arbitration.
Thank you.